Our next case then is Horrigan versus Mould. Each party will have 15 minutes to present their argument. Details may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
I would like to reserve 5 minutes.
Okay. I will keep track of that
Thank you.
here, and you can see it. You're the top circle up there if you're looking over that direction. If you do not, I'll try to let you know when you're about a minute left in your initial time to give you the warning that you're getting close to rebuttal. If you go over that, we'll take off your rebuttal. And counsel, I'll try to let you know you're the middle circle. I'll try to let you know about a minute left.
Thank you.
You're there, I'll give you a warning. The arguments are being recorded, so when you present your argument, please come up to the podium. Introduce yourself. Please stay behind the podium. Because we're video, keep that. It's okay. we're recording you by video and audio as well, so please be loud as we can hear you. Do not use the name of any child, minor, or victim during your argument. Don't know the apply in this case, but if you would, please use an initial for example, like a child. With that, we read your brief and ready to proceed whenever you are.
Thank you, Your Honors. My name is Leslie Weiss, and I'm here on behalf of Deborah Horrigan, who is the appellant. This case involves a post-decree matter involving the contractual terms in the separation agreement and the disposition and proceeds from a business that the ex-wife would be entitled to. There was a provision in there which states that there was a 60-month period in the event that husband receives proceeds related to the businesses, including but not limited to an agreed sale, buyout, settlement, or judgment, husband shall pay wife 10% of the net proceeds. The question became whether or not his receipt of a judgment, which he did receive within the 5-year period, constituted to fall under those terms. And it's our argument that the contract reads in that way. The opposing counsel will insert other words when interpreting this phrase, like it deals with when, inserting the word when, or inserting the word funds instead of proceeds, and so forth. So in this case, we did have a hearing, and the ex-wife came and she testified. And a contract is looked at as to the intent of the parties. She was the only one that testified. The ex-husband offered no testimony regarding the intent of the parties, and she was clear in testifying that it was her understanding that the proceeds included those items, agreed sale, buyout, settlement, or judgment, if those were to occur within the 5-year period. Prior to the case coming to trial, I did also assert that there were discovery issues. We were first with a magistrate. There's arguments on the record regarding the discovery issues. And with regards to the discovery, we issued discovery when the case began, but we were not permitted to proceed with discovery.
It is unclear to me from the brief.
Pardon?
Is there an order on the record or somewhere in a transcript where we can see where the magistrate said, no discovery shall take place? Or is that, I can't see.
There was no order, okay, but there also was no discovery order at all, as far as like deadlines and so forth. However, there were briefs on whether or not discovery could occur. Now, I've never had that happen to me ever in a case before, but my understanding, and the wife testified as well, was that we were not permitted to proceed with discovery. We were to submit the briefs and that there would be a ruling thereafter. The case then was transferred to the judge, and at that point, informally, the judge said, go ahead with discovery, and that's what happened.
And then a discovery schedule was set at that point in time, specifically on the record?
Well, technically, there was no schedule for discovery. Again, there was no formal schedule, and there was a limited amount of time, and the case was set for a final hearing. During that time, I did break my arm, and it was a pretty serious break. I had to have surgery and so forth. And in that short period of time, it was difficult to conduct the discovery in a very short period of time. It was roughly like 2 months. I did get the discovery out, and the response was, which is in one of the exhibits, a lot of the responses were that it's privileged information and therefore it was not supplied. There was not a motion for protective order, so at the time that I could file the motion to compel, in that brief period of time, it was filed roughly, I believe, 7 days prior to the hearing. Also,
in my recollection, was there the motion to continue along with the motion to compel?
Yes, there was also a motion to continue in order to get the discovery. It's basically the purpose of that. And that was denied as well, so.
Was there an in-camera review of the confidential settlement agreement?
There was an in-camera review by the judge, but we were not permitted. We did file a motion for that as well so that we could look at the documents, and that was never ruled on and never permitted. And the final entry does speak from the judge saying that it's not necessary. You know, he made some kind of interpretation, but I can't even argue to it because I don't know what it says. I don't know what the terms are, which leaves us at a total loss. And again, that could have been something, had we seen it, that we would protect it and put it on the where it wouldn't be seen by everyone else. It's our position that we should have been able to see those documents, and we'll never know. Well, I can gather from some of the exhibits, if you look at the exhibits that were attached, specifically the 11.1, 11.2, 11.3, there were some, in the Lorain County case, there were some documents that were admitted as exhibits, and it discusses that the ex-husband did not, the payment could come anywhere as late as December of 2023, which would have been beyond the period of time. And that would be something that the ex-husband was involved in formulating when he did that agreed entry, knowing that that was beyond the time. There also was a motion filed, if you look at the email attached to Exhibit 11-2, there were, part of the agreement apparently required mortgages to secure the payment to be done. And those mortgages were submitted to the ex-husband in March well before the August date, and that was ignored. And our motion was filed with, even before they eventually, the ex-husband eventually filed a motion to enforce, to get those mortgages in place, knowing that, again, it was beyond the 5-year period. So it's our position that that's bad faith on part of the ex-husband. He knew what he was doing. He didn't advise the wife as this was going along. She could have been a party to this. She could have been involved, and she didn't find out until close to the end. And then he manipulated it in such a way so that it would be beyond the 5-year period. With regards to the bad faith, he's benefiting from that, and he's benefiting from the way that he contracted. As far as the divorce action, domestic relations court is a court of equity, and the parties were dividing a property interest. So this was something that each one should be entitled to. Unfortunately for the wife, it was not titled in her name, so she didn't have the access to it that the husband had. So again, he's able to control the disposition because of his position and being able to have access to it.
But that was all known at the time the agreement was drawn up. And see, the trial court was saying this agreement was clear, it says what it says, and we're gonna hold the party to what it says.
It is true that it was known, but I don't think the intent was for the one party to be able to manipulate the system to keep the other party.
Well, that assumes that the system was manipulated, which in part depends upon us knowing what happened in the Lorraine County case and seeing this decision, or this judgment or this entry dividing the sale of this property, which is under seal at this point in time, as I understand.
The only thing that's under seal with the Lorraine County case is the actual agreement.
Right, the settlement agreement. So
Yeah.
we have, you presume, it seemed to me your argument is based upon that agreement was somehow unfair because it allowed husband to stretch out when their money's going to come in so they can make it after the 5 years. And I understand at this point in time that we don't yet have that exhibit in the record that was admitted under seal. Is that your understanding as well?
We don't have the agreement, but we do have exhibits from the.
Well, I'm talking about the agreement.
No, we do
So
not.
the agreement's not here, and as my understanding is you were trying to figure out how to get that up to us or figure out how to get an original copy of that for our review. Is that correct?
Yes, we were not able to review it.
And you're still working on that, fair?
But even so, there were exhibits from the Lorraine County case
That are exhibits in this case.
that are exhibits here in this appeal, and at the trial, they were admitted as evidence, and they are indicative as to, you can see what some of the terms of the settlement agreement was by reading those pleadings.
But didn't the trial court in its entry specifically talk about the evidence of husband being able to maneuver funds or delay funds based on the acrimonious nature of what happened with the business? In other words, there's a little tag in there that says we don't believe that the husband would have been able to. It's very acrimonious with his business partners. I mean, the trial court spoke to it, correct?
The trial court, I believe he did speak to it, but it doesn't, the exhibits that we presented speak for themselves. They were admitted, and there was no testimony contrary to that, stating that that did not happen. So I feel that's compelling. I feel that's something that was there. So combined with my own client's testimony, and he also told her over and over again, you're not going to see a penny, you're not getting anything, many, many times. So there was that. And including in those exhibits, there's indications that, again, that March 30th date of receiving the mortgages. So the mortgages apparently were a condition that had to be met in order for the proceeds for the whole contract that we're not able to see. And because that wasn't met, that was in part causing the delay. And again, there's in those motions or pleadings, it's stated that the ex-husband purposely delayed in that manner by not doing anything. And then after, actually in December, during our pending case, that's when he filed to say, hey, you never did those mortgages and you need to do that in order for the finances to be finalized.
We're about a minute left in your initial time.
I'm gonna.
You'll have 5 minutes for rebuttal.
Yep.
Counsel, I know, be careful when you're coming up. I will apologize, I did not start the accountant's time on time, so I think you got a little extra time. If we get to the end and remind me if you're still trying to present things, I'll give you an extra case. I don't know how long it was, but I know I didn't start at that time, so.
Understood.
Okay.
Thank you. Good afternoon, and may it please the court, Brianna Perslipsky here on behalf of the appellee and cross appellant, Gary Mould. I'd like to start with the issue of discovery in this case. So, we have this initial motion which was filed in June of 2023, and the hearing which did not go forward until a year later, more than. That was on September 10th, 2024. There was ample time to conduct discovery, and as Your Honor noted, there was never any order preventing either party from conducting or requesting discovery. This was raised during the hearing. The trial court, during the hearing, in fact, had one of the assistants pull the docket to ensure that there had been no order preventing discovery. And in fact, discovery had been served almost immediately after that initial motion was filed in June of 2023. So while I understand that there was a motion filed to conduct discovery that was opposed, there was never actually any order preventing discovery. And certainly in the interim, there were multiple meetings with the court. In March, there was a conference where the parties agreed to brief the issue of the interpretation of the agreement. At that point, discovery there could have been a deadline for discovery set. That was not done until June of 2024. At that point, the parties agreed 30 days, with the hearing then falling in September. So there was ample time for discovery to have been done or requested or a schedule set if that was the concern. And I would also note a set of discovery had already been propounded a year before. So, to the extent that the appellant needed time to do anything, the discovery had already been prepared. I do note that the set that was propounded in 2024 was different than the set done in 2023. And specifically, I'd like to note, we received these requests at the end of July. The schedule was set in June, so there was about a month of downtime between discovery being opened and the requests being issued. That set contained 18 requests for production of documents, over 30 interrogatories, over 40 if we're counting subparts. So it was it was a pretty extensive set. Nonetheless, we got those responses back August 29th. The motion to compel was filed September 3rd, and then the hearing was September 10th. So there was not ample time for us to even respond to the motion to compel, which the trial court did hear argument on the day of the hearing. All that to say, the trial court has the ability and discretion to manage its docket, and given the lack of action by the appellant here, it did not err in setting the discovery schedule that it did, which the parties agreed upon. And as the trial court even noted during the hearing, there were no depositions requested at any point. And it did its own in-camera review of the settlement agreement that we've discussed. It found none of that was relevant or discoverable, so it denied the request for that. And that ruling is also in the transcript. I believe there was a remark that the in-camera review didn't receive a ruling or was not actually ruled on. That occurred during the hearing. Regarding the actual agreement itself and its interpretation, as this court is likely well aware, when we review a contract, we're looking at the four corners. So in terms of what the agreement actually means, what the parties intend, we're looking at the language of the agreement and not testimony. There was testimony at the hearing regarding what the parties intended, but in terms of how we interpret this, we are looking at what the agreement actually says. And the agreement says that, these net proceeds, and I note the term net, meaning, proceeds that are in excess of what was spent to obtain them, that are received within the 60-month period. So, in terms of what was received, the only evidence of anything being received within that 60-month period is a $72,000 tax distribution, which is the subject of our cross appeal. And we had testimony from our client. We prepared an affidavit, and then his discovery responses were actually entered into evidence at the hearing, which stated that there were no net proceeds based off of that $7,200 tax distribution, simply because that resulted from the separate litigation within his family. That was 4 years of litigation. He, his affidavit stated that he had spent more than $2,000 in attorney's fees. So in terms of net proceeds, there was no net. And then also, I'd just like to clarify.
Was evidence of that presented? Was Mr. Mould's affidavit being offered and received by the court as an exhibit?
So it was an exhibit, the briefing that the court, it was offered as an exhibit either to the briefing in June, or I believe there was another motion that had been filed by us. It's in the record, but I would note that our discovery responses, which were submitted into evidence at the hearing, there's a response in there that, the net proceeds, 10% of the net proceeds would be zero. And it also clarifies that that $72,000 payment was a tax distribution, which I'd just like to clarify. A tax distribution in a situation like this is not, it's not a proceed as, considered by this agreement. It's a payment by the company so that the members can pay their taxes. It's not a dividend or a profit. It's, the individual members bear the tax burden, and so here is your payment for taxes. And the reason I'd like to highlight that is because when we're discussing the issue of net proceeds, the language is structured so that anything that would be considered a net proceed or a profit would be shared, but anything that is a loss is not going to put my client in a position where he's already out money and then has to pay more. So that's why things like attorney's fees are especially relevant, specifically because in this situation he paid more than he ultimately received, and what he received was a payment for, it was a tax distribution. It was meant for tax payments. It wasn't a net benefit for him. It was for taxes.
Was it, just out of curiosity, we have
Sure.
this affidavit that says the $207,000. I think I understood you to say there's other disputes going on around between the family. How do we know the 207 all went for the sale of the proceeds, the sale of the business? And they
So-
weren't for other things involved in this family disputes?
So by dispute, I mean the litigation in Lorraine County. In terms of the affidavit, my understanding is that applies to that litigation, which, as I said, we do have in the record, and certainly this court can take judicial notice of the docket in that case. That case was filed in 2019. It was litigated until 2023. I understand there's some extrapolation there, but certainly for 4 years of litigation, $200,000 in attorney's
And
fees.
is whatever final agreement was admitted and made in that Lorraine County case, I understand it was given to this judge to review in camera,
Yes.
and we're still searching for that in the record. Is that accurate?
So,
I understand that we don't have a copy of that ourselves right now.
okay.
Has that been communicated to counsel? Is counsel trying to find a copy of that agreement for us to review?
Certainly, if this court is looking for it, I was not aware that it was missing from the record, but I can,
Okay.
go through our file and, ensure that this is.
I don't know, the trial court has it somewhere in the exhibits and just didn't get sent to us, and it's somewhere
Sure.
because it's in camera and stored in a separate location, and they may have it at some point, being a visiting judge, perhaps it's not stored the way it might normally be because it's a visiting judge who's involved.
Of course, I can look into that. I will note, while of course I'm glad to be of service to this court, it is the appellant's burden to ensure that the record is complete, though I.
Agreed, and we're sort of that. Now, the appellant indicates that they never had a chance to review that.
Correct, it was an in-camera review to see whether it was discoverable. And there
Did the trial court find, the trial court rely upon it in any way, shape, or form, that decision?
Not that I'm aware, certainly its decision doesn't indicate that it did. There were confidentiality concerns, which is why there was an in-camera review. And so I don't believe from reviewing the decision that the trial court relied upon it at all. It seems, as I read it, there was ample testimony and evidence presented, as well as a lack of evidence on behalf of the appellant.
Well, counsel, didn't the trial court reference it, as Judge Hensel mentioned?
Reference it,
reference it as evidence that he wasn't dragging his feet. Because if you look at it, it's,
So my understanding is he references that litigation, and the fact that, you know, there was a fair amount of contention between my client and his family, which is more from the broad scope of that litigation than the agreement itself.
not the agreement itself.
Yes, that's my understanding.
So here's what it says. Plaintiff alleges that that he manipulated funds. Okay, here's the exact quote. The confidential agreement, including the lawsuit between defendant and his brothers in Lorraine County Court, does not corroborate this allegation. Then says, it's reasonable to assume that if manipulation took place, the defendant would of necessity needed his brother's cooperation, which the confidentiality agreement that we don't see as the Court of Appeals indicates that he did not have. So I think that's maybe what Judge Sutton's getting at in terms of if you say the court did not use that confidentiality agreement, it seems like it did to refute the allegation that, at least in part, that plaintiff did not meet her burden on the manipulation of the timing. Does that
I
make
see,
sense?
hearing that language, it does seem at least part of that is just based off of the litigation itself, separate from the agreement. I could say perhaps the trial court was looking to the fact that there needed to be a confidential settlement agreement in its, you know, at all in order for this litigation to be resolved. And certainly there were communications and filings presented during the evidentiary hearing, which would, you know, certainly suggest that it was not, that things were not exactly cooperative between my client and his family.
But counsel, you would agree that the confidential settlement agreement is referenced directly about.
It is referenced, yes, yes.
And then to that end, with respect to the in the record but not testified to at the hearing affidavit of the client. So it seems like the trial court said that affidavit means nothing because nobody was here at the actual hearing. That confidentiality agreement and the affidavit, did that come in? It didn't come into the record at the hearing, it came in prior to, like the affidavit did, right?
Yes, that's my understanding. It was submitted and then reviewed by the court prior to the hearing.
Okay, so we come to the actual hearing date and we don't have anything on that date submitted by husband as to whether or not these are net proceeds or tax distribution or anything.
On the day of the hearing?
Yeah, on the day of the hearing.
I do not believe anything was submitted by husband, by my client, though I would again note that our discovery responses were submitted by appellant. So those are in the record.
So is the hearing, and obviously, I'm sorry to take up so much time, but now that I'm on this train, is the hearing that was set, the final hearing where we got the judgment, is that a hearing on the motion where all the documents were submitted on that motion, or is it the separate hearing of the court that was on the docket when the whole thing started? Does that make sense to you?
My understanding is that it was an evidentiary hearing to resolve everything. So that's why we
So
have
not just the motion?
the motion. Maybe I should clarify which motion.
Sure. It's a good question. The motion, you wouldn't have submitted discovery to the court as opposed to two opposing counsel if there wasn't some motion pending, right?
So
Prior to the hearing, final hearing.
the central motion is the motion for the proceeds, which was filed in June 2023.
Okay.
And so that was a hearing centered around that motion, though there were other motions that were ruled upon that date. So, you know, that's a hearing to essentially resolve all of the post-decree issues, which there was only one, the issue of proceeds.
Thank you.
And council, just a couple more things in terms of clarification for me. We spoke a moment ago about the affidavit, and when the decision was made on the $72,500 going to the wife, the trial court, didn't they state in their judgment entry that pleadings are not evidence and that Mr. Mould's affidavit is not evidence unless it was offered and received by the court as an exhibit, and it wasn't offered as an exhibit?
The trial court, yes, it does say that.
Okay.
And are you disputing that? Do you agree the affidavit was never offered as an exhibit, or are you telling us, no, that's not accurate? The affidavit was offered as an exhibit.
Well, so it was not offered as an exhibit at the hearing, but it was offered as an exhibit as part of the briefing, which the hearing was, which was a prelude to the hearing. And again, while the exact number of fees is not indicated in our discovery responses, the court did receive at least that information, clarifying what the purpose of the tax distribution, as well as noting that there were no net proceeds. So those were offered as exhibits to the trial court.
Counsel, one other thing, I'm sorry.
I was going to say, I was giving you an extra minute, but please answer Judge Sutton's question no matter what.
Counsel, you said early on in your presentation here, I want to make sure I understand, that the parties agreed to the discovery schedule eventually. Is that accurate?
That's my understanding. So I was not personally at this conference, but my understanding is that discovery was requested and that the court allotted 60 days. Certainly, if 60 days was not enough, appellant could have requested additional time at the time that decision was made, or earlier than the days leading up to the hearing, could have moved for additional time.
So is that how they agreed, by not requesting more? Or was there agreement?
I was not at that
Okay.
hearing, but my
Okay.
understanding is, yeah.
I appreciate it.
Is there a order on the record at all after that hearing setting that, saying 60 days for discovery? Was it just an order saying the trial date is this date? What came out in writing from the court after this meeting where they seemed to set the trial, and you're saying set a discovery timeframe?
Off the top of my head, I do not recall what was put on the docket, though given that discovery was issued 30 days later, and it is acknowledged by appellant that, that initial 60 days did come at the end of June. That did occur, given that, it's corroborated.
No, we give you an extra 3 minutes to answer our question and some extra time. If you would briefly conclude at this point in time?
Yeah, of course. As such, I respectfully ask that this court would overrule appellant's assignment of error and reverse the trial court below as it relates to our cross appeal and the $7,200 award. Thank you.
Thank you, Counsel.
First, I'll address discovery because I was at the hearing, all of the hearings. As far as the initial discovery, again, done in September 2023, that was shortly after the case was initiated. Again, we were required to submit briefs on whether or not we could even conduct discovery. When we talked.
So the record will show those briefs in there regarding whether you could discover.
Yeah, they are a part of
discovery,
the-
but no specific order, but we would see these
Yeah.
briefs saying, can we do discovery or not? Okay.
And the court never ruled on them either way. There was never anything put on the docket ruling on those. There was never anything ruling on the briefing that was done as far as what our interpretation of the divorce decree clause was. That also was never done. Even those briefs are also on the record. So when we were given the basically 60 days, you're coming up with the 60 days, I'm assuming, because there was a hearing set for the September 10th. And so it wasn't discussed, oh, you just had 60 days. It was, we were told There was no specific agreement. We were told this is the date of the hearing.
So I take it from our conversations, there's no transcript of the hearing when the trial date was set to tell us what was or wasn't said about discovery. Is that fair?
There's no transcript that I am aware of.
And the only order we're going to see is an order that says the trial date is set for such and such date.
That's
It doesn't say a
correct.
thing about discovery one way or the other.
That's correct. And even if you look at the judge, the entry talking about some agreement in his findings, in his judgment entry, there is, again, like you said, there is no specific agreement anywhere. You will not find it. As far...
And you asked for a continuance and to compel. Was there any discussion on the record or any orders denying that or any on the record discussion about denying this because ABC?
That is in the judgment entry. The judge specifically said that he was going to deny the motion to compel and deny the motion for continuance. And there's a bunch of language in there about that, saying,
Okay.
well, you know, you could have asked for more time, you agreed to this, all that kind of stuff.
Okay.
But there was no testimony put on regarding that because there just wasn't. That would have been an informal hearing.
Counsel, will the record tell us when the wife found out about the confidential settlement agreement? Because you said that she didn't know about it.
Yeah, so there is probably some
Or the
testimony.
litigation, did she know about the litigation?
She did not know about the litigation until shortly. I think she did testify to that.
So is there something in the record that will tell us more about that?
There might be something in there that she heard from, you know, people talking, going out. They're from the same neighborhood.
Okay. We'll look.
Possibly, I don't know. So, but there is testimony, there's gotta be testimony, because there is testimony that she was not notified by the husband. He did not tell her. And in fact, they had.
Was there some obligation that he was under to notify her?
It's not stated in there that there is no obligation specifically stated in the decree.
It just speaks to proceeds received.
I'm not sure I understand the question.
Well, it's okay. We'll just move along.
My feeling about the contract and our position is that we feel it is not ambiguous, however, we have an argument. So doesn't that mean it is ambiguous? We have a disagreement, they're just looking at it one way and we're looking at it the other way. And the law is supposed to interpret and listen to the intent of the parties and rule on what it actually means. And again, we're just looking at the exact language which says proceeds and then directly following that, including but not limited to. My interpretation of that and our position is that proceeds is going back to that word.
Can you speak to the use of the word receive though? Receive proceeds?
Well, when you're defining proceeds to include, then a receipt of, say, a judgment, what is the date that you received the judgment? And so our interpretation would be that proceeds includes a judgment, and the judgment was received on or about May 30th, 2023, I believe it was.
Thank you.
Now, note your vote time is up. Counsel, you may briefly conclude.
And we're asking that you reverse the decision and find that the terms allow the wife to receive her share or in the alternative remand for further discovery. And thank you, Your Honors.
Thank you, and I thank you both for your presentations on behalf of the court this morning. The court will take a matter under advisement and issue a decision in due course. When that decision is made, it will be mailed in by the clerk of courts and also be posted on the High Supreme Court website. With that, I know the court is now adjourned until this Thursday, July 17th.